When parents do not separate on good terms, they often have concerns about the other parent's priorities, particularly when young children or infants are involved. When a separation is going to be high conflict, we very frequently hear from a parent who needs to start court right away without trying any of the better ways to work things out because the kids have been completely cut off from him or her. The reasons why this happened vary, from domestic violence to concerns about child abuse, to disagreements over parenting strategies, to questions about the other parent's competence, to issues over child support and the children's wishes. But there are only certain reasons that judges believe justify cutting off a parent from the children. Any other excuse is going to get a parent in serious family court trouble, and that parent may even be cut off from the kids by court order. So in this episode of the Ontario Family Law Podcast, I will look at what does and what does not justify cutting out the other parent from the children's lives. I'm John Schuman, a certified specialist in family law in Ontario. I'm also a mediator, arbitrator, and collaborative lawyer. This podcast is a companion to my book, Guide to the Basics of Ontario Family Law, which is available on the iBookstore, Amazon, Kobo, and in fine bookstores. The guiding principle in family court, family arbitrations, and all family law matters is supposed to be the best interest of the children. So everything a separated parent does should be governed by what is best for the children, not what is best for the parent. The concept of the best interest is not an airy-fairy concept. In the Family Law and Divorce Act changes from 2021, there are specific definitions and guidance about what exactly is in the children's best interest. In episode 59, I went over the changes to the parenting laws in 2021 and explained how they influence judges and arbitrators' decisions. One big takeaway from that video is that how will a parent support the children's relationship with the other parent counts as at least two factors in the determination of what parenting situation is in the children's best interest. Many other factors, such as the children's wishes, the history of care of the child, and the parenting abilities of each parent are just one factor each. While Ontario's family laws do not create a presumption of shared parenting for many family court judges, the emphasis on the children having a meaningful relationship with each parent translates into that as much as possible, each parent should treat the other parent as an equal, and so should the court. Social science research looking into family law decisions found that judges place more weight on equal parenting than any other factors, such as family violence, the needs of the children, and certainly the children's views and preferences. In that research, circumstances where the children are being denied a relationship with one parent trump all other concerns, sometimes erasing them from consideration, and can result in an order that makes the parent who is being denied a relationship with the kids into the sole parent for the children, at least for a while. That is not how the family laws are written, but it does reflect what many family court judges are doing. So considering that, let's look at the reasons some parents use to justify cutting the children off from the other parent. One frequent reason is that the child is an infant and the other parent either is not ready or supposedly does not have the skills to parent an infant. There is rarely any evidence to support that conclusion, as often both parents to an infant are new parents and are new to parenting that infant. Judges have to base their decision, especially decisions related to alleged child maltreatment, on evidence, not speculation or stereotypes. There is a consideration that the medical literature strongly suggests that infants should be breastfed until they are at least 6 months of age. So unless a mother is clearly abusive, neglectful, or unable to parent because of substance abuse or another condition, an infant is going to end up spending a lot of time with that mother. However, judges also weigh that against the importance of the child being able to bond with both parents, and so that means the father has to spend a lot of time with that infant too. That time has to be parenting time, not just visiting. So the infant's father needs to be as actively involved in all aspects of caring for the child, and for that bonding to happen, the father has to be actively parenting several times a week. How long each parenting time lasts is less important than frequency. But absent actual evidence of abuse or neglect, or the inability of a parent to participate because of employment or distance or similar reasons, both parents should be actively involved in raising an infant. Another justification that parents use to cut off or restrict the other parent's time is that the parent is behind in or is not paying child support. Make no mistake, judges have a very negative impression of parents who do not pay child support. They view that parent is not wanting to provide for his or her child, and that is a strong indication that the parent does not have the right priorities to be a good parent. But parenting and child support are completely separate legal issues. One is not supposed to impact the other, so a parent falling behind in child support or even not paying it at all is not a justification for the other parent to cut off parenting time. Ontario judges even had problems with no child support, no contact agreements because social science research shows that children benefit from having a relationship with both parents. So children should not be denied that relationship unless it is extremely harmful. At best, not paying child support indicates a lack of interest or caring for the children, which is one of the things the judge can take into account when deciding what parenting order is in the children's best interest. But not paying child support is not in itself a reason to take a parent away from the children entirely. If you speak to anyone involved with marginalized or disadvantaged people in family court, you'll hear that judges do not give much, if any, consideration to family violence. This is despite explicit requirements in both the Divorce Act and the Children's Law Reform Act that the family court take that violence into account when making parenting orders, and the requirement on the Form 35.1 parenting affidavit that parents report any family violence to the court. Part of this may be that there are a lot of allegations of family violence in family court, and not all of them withstand scrutiny. In academic research that I did more than 20 years ago, I discovered that there are allegations of violence that are made simply to get an upper hand in litigation. But also there are allegations of abuse that arise from circumstances surrounding the breakdown of the relationship, where the partners have lost trust in each other and are suspicious of each other's motives and actions, which can lead to mistaken beliefs about the former partner's intentions, and even to be too quick to assume that the former partner is trying to or has been abusive. Obviously, a judge is not going to cut off a parent because of allegations against that parent that are false or mistaken, but that judge will be very concerned about the motives and parenting ability of someone who makes untrue allegations for any reason that impact the children, especially their relationship with the other parent. But the issue is more complicated than the court being unkind places to victims of violence. The law requires that judges consider the nature, seriousness, frequency of family violence, whether there is a pattern of coercive controlling behavior, and what harm or safety concerns that violence may continue to inflict upon the children. Put another way, not all family violence is of equal concern. A single or even a limited number of times when one parent becomes frustrated and acts angrily or in an intimidating manner or even commits a violent assault is very different from a parent who uses behavior, often subtle behavior, without explicit or implied physical violence to coerce or control another family member over a period of time. This is behavior designed to keep other family members constantly intimidated and to use that intimidation to deprive the other family members of their free will. That behavior is harmful to the other family members, especially the children. Proponents of parental alienation as a disorder and of parenting alienation treatment programs are very clear in the opinion that parental alienation behavior is a form of abuse. Not only that, but actions designed to deprive one parent of a relationship with the children is a form of coercive controlling family violence that is much more serious than many types of physical or sexual violence. Consequently, a parent who uses family violence as a justification to cut off the children from the other parent may find him or herself being accused of coercive controlling behavior and consequently having the children taken away entirely as a result of raising those family violence concerns. As a result, it's often only extreme forms of family violence that result in very serious harm that will justify one parent stopping the other from parenting the kids. Except in cases where there is no question that there will be a conviction in a criminal court for violence directed at the children, it is better for a parent to seek advice from a good family law lawyer and other professionals about how to protect children from family violence in family court. Differences in parenting styles or the rules between houses are not a reason to restrict another parent's opportunity to parent the children. Parents are allowed to parent in their own style, on their own time. The exception to this is when there is a risk that a parent will endanger the children. As I noted before, judges are usually very skeptical of the suspicions that separated parents have that the other parent is putting the children at risk. After separation, the breakdown of trust causes many parents to believe that every aspect of their ex's life is driven by evil intentions, and that is rarely the case. Consequently, judges will not act on suspicions. They will only act on evidence. See the previous episode and my book for the importance of evidence in family court. It is very rare for there to be evidence that a parent will put children at risk of harm until the parent has actually put the children at risk of harm. So it is very difficult to get a judge to restrict parenting without some compelling evidence of previous very bad parenting. The exception to this is when a parent suffers from a diagnosed mental illness or substance abuse problem. Again, there has to be clear evidence of this type of challenge, usually in the form of a diagnosis. However, as these types of challenges often lead people to act irrationally or without self-control, judges are more inclined to play it safe with the children and restrict parenting time until there is evidence that these conditions are under control or do not pose a risk to the children. One specific difference of opinion on parenting matters that can lead to significant problems is with regard to parents introducing new partners. It is a common occurrence for one parent to be opposed to the other parent introducing a new partner to the kids, or to say that it is too soon to do that. The reality is that once a new partner becomes permanent, the kids will have to meet him or her, and the new partner will have to be part of the children's lives. Judges understand and expect that. And they also don't like parents being bitter or jealous of an ex having a new partner and basing parenting demands on those feelings. Ideally, the introduction of new partners is something that the parents should discuss, coordinate, and get professional advice on, as introducing new partners in a way that is not sensitive to the kids can really strain a parent-child relationship. But the lack of that cooperation is not a reason for one parent to stop the kids from seeing their other parent who has a new partner. If the introduction is done badly, then some professional intervention may be necessary. But a judge is going to be very critical and may even take parenting time away from a parent who restricts the kid's time with the other parent because the other parent has a new partner. Doing so just looks like vindictive jealousness that creates a disregard for the children's needs and best interests. Another time when parents feel they should restrict the children's time with the other parent is when the family is involved with the Children's Aid Society. Note that judges always view with suspicion when one parent reports the other to the Children's Aid Society. It seems like a litigation tactic or an attempt to get the upper hand. But even when a teacher or other professional makes the report, and for why a professional might make a report, check out episode 70, parents need to keep in mind that Children's Aid Societies do not have the authority to suspend a parenting order or parenting agreement. Although Children's Aid Society may want to suspend contact between a parent and child while it does an investigation, it does not have the authority to do that. And so it must either get the parents to agree to it, or it has to go to court and get a court order restricting a parent's involvement with the children. So after separation, one parent cannot stop the children from seeing the other parent just because the Children's Aid Society asks for that. A judge will not support that decision if the other parent objects, and will say that if the Children's Aid Society wanted to cut off a parent, the agency can start a court proceeding to do that. A final reason why parents may restrict their ex's time with the kids is because they say that is what the children want. This is a justification that has all kinds of problems. There is some research that is not universally accepted that even abused kids want to maintain contact with their abusive parents. Regardless of the strength of that research, judges do not like kids having to pick sides between their parents, and do not like kids having to say they like one parent more than the other, or that they don't want to spend time with the other parent. Placing a child in that situation creates all kinds of unhealthy feelings that can lead to mental illness. It creates loyalty conflicts, guilt, embarrassment, and a feeling that in rejecting a parent, the child is rejecting half of him or herself. It can lead to all kinds of problems down the road. Don't take this as me saying that kids should not have a voice. The UN Convention on the Rights of the Child guarantees children the right to have a voice on matters that affect them. But having a child say they don't like a parent or forcing a child to choose is not a child-focused approach. Often the issue is not that the children wants to show more love for one parent than the other. Usually it comes down to the practicalities of life, like dad doesn't do homework with me, or mom won't take me to swimming or cheer practice, or I don't like dad's food, or mom always works late, or dad lives closer to my friends and I want to spend more time with my friends. These are all child-centered reasons why a child may want a change to a parenting schedule. Under the 2021 changes to the family laws, which require a child-centered approach to parenting issues, these concerns of the children are reasons to adjust the parenting schedule and parenting responsibilities so that each parent is doing as much parenting as she or he is able to do. They are not reasons to restrict the children's contact with the other parent. To summarize, the general rule, which has very few exceptions, is that one parent should not unilaterally restrict the children's time with the other parent. Doing so can have serious negative consequences, including losing all parenting time and responsibilities with the kids. The parent who tries to restrict another parent's parenting time can end up losing all of his or her parenting time. It is only with really compelling evidence, and to know whether that evidence is compelling, a parent should speak to a good family law lawyer, that a parent can restrict the children's access to the other parent. And even then, the parent must run to court as soon as possible to get the court's permission to continue that action. Parenting differences, deficiencies in child support, the children's wishes, and even family violence directed towards the kids may not be accepted by the judge as being justification for cutting out the other parent, with the result that the parent who has the kids may lose the kids and perhaps all contact with the kids in a court order. If you need some more general family law guidance, or you need to understand Ontario family law better so you can make better decisions, if you need to know the best parenting options after separation, or if you need to better understand how finances work after separation or divorce, or if you need some tips for how best to make these difficult types of decisions, get a copy of my book, Guide to the Basics of Ontario Family Law. You can access it immediately on the iBookstore on Amazon for the Kindle version, or you can download it for Kobo. Amazon can deliver the paperback version directly to your doorstep. You can also get a lot more Ontario family law information on www.humanlaw.ca. Not only are there hundreds of pages of family law information and links, but there are links to get my book and links to reach me and my office to meet with either me or one of my colleagues. Because it is always best to get a lawyer who can give you expert advice that's specific to your situation. In addition to my website, keep up to date on family and children's law issues by liking my Facebook page, following me on Twitter at @SchumannFamLaw, and finding me on LinkedIn. Of course, please subscribe to my YouTube channel and hit the notification bell to keep up to date. You can get the audio versions of the Ontario Family Law podcast in all major podcast services, including Apple Podcasts, Spotify, Google Podcasts, and many more. They are also available at www.humanlaw.ca. Thanks for participating in this podcast. We will get together again soon.